I want to tell you a story, and this is probably the story that made the most difference in my law practice just early on as I started practicing law. This is the story about Mrs. Will and Mrs. Trust. During one week, I was visited by two widow ladies. They didn't know each other, they didn't come together, they didn't come at the same time. The first lady I'm going to call Mrs. Will. That's not her real name, but you'll see why I call her that in the story. She said, "Mr. Allen, I've been to my doctor and he tells me I'm suffering from terminal cancer. I have only about 6 months left to live. I'd like to have a new will prepared so I can leave everything in proper order for my family." And so we visited for a while. I took some notes, and she had an average size estate. She wasn't wealthy, but she owned her home. She owned a second home in Colorado. She had some stocks, some bonds, some bank accounts, and she owned an antique doll collection, which her granddaughter had fallen in love with. So I prepared a will for her. In that will, I told who was going to receive what. Her granddaughter was going to receive that antique doll collection, among other things. She came back and reviewed the will and found it was to her liking, so she signed it and went her way thinking everything had been taken care of. Well, about 6 months later, Mr. Will, Mrs. Will's son, came to see me. He said, "Mrs. Will passed away, and I know you prepared her will for us, so I'd like your help in settling the estate. I'm named as the personal representative in her will." So I told him what his duties would be. First of all, we'd have to file a probate with the county courthouse, give notice to all the heirs and beneficiaries, give a notice to all the creditors. The creditors then had time to file claims against the estate. Since she had property in Colorado, real estate there, we also had to open an ancillary probate in the state of Colorado to take care of the Colorado property. That meant we had to hire another attorney in Colorado, and he had to go through the same procedures for that one piece of real estate in Colorado. So we began that process. I filed the papers with the courthouse, and everything was going along quite well, but in about 3 or 4 weeks after I began the process, Mr. Will came running into my office, and he was quite a bit agitated. He said, "Mr. Allen, what have you done to me?" I said, "I don't know. What have I done?" He said, "That antique doll collection that was left to Mrs. Will's granddaughter, that was Mr. Will's daughter by a prior marriage. He'd been divorced from his wife, and his wife had custody of this daughter. Well, I gave notice to all the heirs and beneficiaries. That granddaughter, his daughter, was one of the heirs because she was to receive that antique doll collection. And so Mr. Will said, now his ex-wife knows where I am living because we gave notice to the granddaughter. And now she has filed a claim in the county court here to collect back child support and alimony. You see, when I'd been divorced, I moved out to Arizona and hadn't told my ex-wife where I was residing. But now she knows, and she's trying to collect this back child support and alimony. I said, well, just because you have disobeyed the law to pay the child support doesn't mean I can avoid giving notice. I suggest you simply pay the back child support and alimony, which is eventually what he did, but he was unhappy at this whole process. Well, then one of the things we had to do is give notice to all the creditors. And there were some creditors of Mrs. Will's estate. Most of them I had records so that I could see that they were valid claims, and so we authorized payment of those claims. But there were some claims that we had no record of, and so I disallowed those. And so those creditors filed claims within the court so that they could get paid for their just debts. Some were disputed and some were authorized by the court. In any event, this made everything take longer and cost more money. Well, then we got to the point we could finally settle the estate, and so I filed a plan for the distribution of the estate, which was based on Mrs. Will's will. That was filed with the court and sent to all the beneficiaries. And do you know that some of those beneficiaries decided they were going to complain about how the estate was going to be distributed? So they filed their motion to have their idea of how the estate should be settled put into action. Well, this caused some additional hearings, more time delays, more costs. Anyway, this estate, there were several other things that happened, but I think you get the idea. It seemed that every step along the way, something happened to cause problems and more time delays and more expense to the settlement of the estate. And the estate was not settled until about 2 years later. the property in Colorado was sold and the money sent to Arizona for the final distribution. About that same week, another lady called me and she asked if I could come and visit her at home because she was bedridden. She was on oxygen. She couldn't travel. She wanted me to come and visit with her about her will because her doctor had told her she had about 6 months left to live. She was dying of terminal cancer. So you see, these cases are very similar. I'm going to call the second lady Mrs. Trust. Again, not her real name. When I went to her home, I found she had about the same size estate as Mrs. Will. She didn't own another piece of property in Colorado, but she owned her home. She had stocks and bonds and bank accounts and was the value about the same as Mrs. Will's estate. So I visited with her a while and she said, "Mr. Allen, I have one other objective in my estate. My husband died about 2 years ago, and we have finally just settled his estate because it did have to go through probate. I want to know if there's something I can do to eliminate the probate." So I said, "Yes, Mrs. Trust, we can set up your estate so that all of your assets are held in a simple, revocable living trust. That means upon your death, the assets will be distributed according to the terms of the trust by someone you have named as your successor trustee. This will be the trust manager." She said that sounded wonderful. "Please prepare the documents." So I did. I prepared all those documents, went back to her home, reviewed everything together, and I found it was to her liking. So she signed the documents, including the trust, the pour-over will, the deed transferring her home into the name of the trust, letters to the banks to make sure the accounts were retitled in the trust name. All of those things were done and sent to the proper places, and I went away thinking everything had been taken care of. About the same time that Mrs. Will died, Mrs. Trust also passed away. Her son also came to see me. He's named in her trust as the one to step in the event of her death and manage the estate until it's to be distributed. He said, "Mr. Allen, Mother died last week, and I know you prepared her trust for her. I want you to help me settle the trust. What do we need to do?" So I explained to him that he and his sister were the beneficiaries of the trust, that they needed to get together and agree on how the assets should be distributed if they wanted any of the personal belongings. But other than that, everything should be distributed 1/2 to the sister and 1/2 to Mr. Trust. And so we prepared the deed and sold the property. All of the assets were assembled together and divided between the brother and sister. Everything was settled within 3 weeks after the death of Mrs. Trust. Well, as you can imagine, that experience taught me there's a great deal of difference in how an estate will be settled depending on how the estate is set up. And now, since that time, I have made it a practice to explain to people when they come to have a new will prepared what the process of distributing an estate through a will amounts to. I have found that many people, when they learn these things, would rather have a revocable living trust prepared to avoid the extent of the distribution through probate. There are still some that would like a will prepared, but at least now I know they're making an educated decision. But if you're in this situation and you're thinking, is a trust going to be beneficial for me, just sit back and ask yourself, do I have certain assets, real estate, stocks and bonds, or other investments that would otherwise require a probate? In most states, that's anywhere from $25,000 to $50,000. You'll need to look that up for your own state. But in the event that your estate is greater than the amount that can be distributed without probate, a revocable living trust makes a good deal of sense for you.